All right, so we are going to go ahead and get started with our event today. We're going to get started with a fact or fiction question. So the question is, applicants are considered to have repayment ability if their proposed monthly housing expense does not exceed 29% of their repayment income. Is that fact or is that fiction? And the answer to that is, as of yesterday, through a Gov delivery message, that is now fiction. Applicants are now considered to have repayment ability if their proposed monthly housing expense does not exceed 34% of their repayment income. All right, and now looking at ratios. So ratios are derived from the repayment income as specified by the lender in Chapter 9 of the Handbook. The PIT ratio encompasses several components. We're going to be looking at the first mortgage, any subordinate liens, homeowners insurance, supplemental property insurance, property taxes, the USDA annual fee, association or project dues for condos, co-ops, or PUDs, as well as any other housing related expenses. Then when we take a look at that total debt ratio, applicants for the guaranteed program are deemed to possess the capacity to repay when their cumulative debt amount is no more than 41% of their repayment income. Now that total debt ratio encompasses the monthly housing expenses in addition to any other monthly credit or debt responsibilities. Now, the lender must document the applicant's debts using records such as the credit report, direct or third-party verifications, court documents, and deposit verifications. All open debts and accounts incurred through the closing date, which would include non-medical collections accounts and non-medical collection accounts and judgments. Those must be taken into account in the total debt calculation and documented in GUS and the loan application. The amounts on the credit report will be used unless there is verification for a different payment amount. Now, if a different amount is used, the lender must provide documentation for the amount used and upload the documentation with the final submission to USDA. Now, the next several screens, we're going to take a look at specific types of debts. Now, in our other trainings, when we talk maybe about income or credit, we usually touch a little bit on how these affect ratios, but we usually don't go too far into detail. So today's training is going to give us that opportunity to dig a little bit deeper into how these specifically affect the ratios. So if we take a look at installment accounts, so accounts with fixed payments such as auto, personal, secured, or unsecured loans, those have to include a monthly payment. If there are 10 or fewer months left for repayment, according to the credit report or verification from the creditor, the monthly debt may be omitted if it's less than 5% of the monthly repayment income. The remaining debt for installment debt can be paid down and reduced to 10 months or less. If omitting the liability, again, please make sure that you double check and verify that it doesn't exceed 5% of the applicant's repayment income. We do find sometimes during post audits of files that those debts are being automatically omitted if there is that less than 10 months. But we find that the debt does exceed 5% of the applicant's repayment income. So again, you want to make sure that if you are omitting those debts, that they do not exceed 5% of the applicant's repayment income. Very important. All right, now then for revolving accounts such as credit cards, lines of credit, secured, unsecured loans, lenders must include the minimum monthly payment documented on the credit report or again, a creditor verification. If the credit report shows an outstanding balance, but there's no minimum monthly payment, the payment would be calculated as 5% of the balance that's reported on the credit report. The lender may obtain a credit account statement or verification from the creditor to document the actual monthly payment and then include that amount in the monthly debts. If the revolving account has no outstanding balance on the credit report, you don't have to estimate a payment and include that in the debt ratio. And if the revolving account has no outstanding balance, we do not require that account to be closed. If there are any 30-day accounts, a credit arrangement requiring the applicant to pay off the full outstanding balance on the account every month is required. The lender may utilize the credit report to document the applicant has paid the outstanding balance for the previous 12 months. If the credit report reflects late payments in the last 12 months, then the lender must include 5% of the outstanding balance in the monthly debts. And 30-day accounts that are paid monthly in full are not included in the total debt ratio. Now, when we look at court-ordered debts, a payment must be included in the debt ratio unless the applicant has a release of liability from the court or creditor and acceptable evidence to document that. Lenders will utilize select pages from the applicable agreement or court order to document the required monthly payment that's due and the duration of that debt. Again, if there are 10 or less payments remaining, the debt may be excluded if it does not exceed that 5% of the monthly repayment income. For GUS transactions, lenders will manually enter these types of obligations as a monthly liability because GUS can't automatically pull these types of debts from the credit report. So these types of liabilities are going to have to be manually entered by the lender. For these types of obligations, they'll be entered as other, and then you'll want to specify the obligation as a court-ordered child support, alimony, garnishment, or whatever the obligation type is. You'll just want to make sure that you notate what it is in GUS. And then the lender must confirm that the repayment agreements are current. And again, today we're talking specifically about Chapter 11 and ratios. If you have any questions about how court-ordered debts may affect credit or eligibility, you can take a look at Chapter 10 of the Handbook. That chapter dives deeper into credit and then eligibility. Student loans. For applicants with outstanding student loans, regardless of the payment status, lenders must use one of the following payments. If the payment amount is above zero, you will use the payment amount reported on the credit report or the actual documented payment. If the payment amount is zero, then you are going to have to use 0.5% of the outstanding loan balance documented on the credit report or the creditor verification. Just a couple quick notes about student loans. If the student loan is in the applicant's name alone, but is being paid by another party, the applicant is still legally responsible for that debt. So a payment still has to be considered, again, based on whatever the payment is, if it's zero or above zero. But if it is reported as an individual debt of theirs, you always have to look at that debt. For student loans that are in a forgiveness plan or program, they do remain the legal responsibility of the applicant until they're released of liability from the creditor. Therefore, because they are still legally responsible for that debt, the appropriate payment must be included. All right, so now we're going to take a look at some situations where an applicant may have mortgage responsibilities that have to be considered. For mortgages of rental properties, Income that's received from rents may only be counted for repayment if received for 24 months or more. Now, again, today's training, we're focusing solely on ratios, and that would be associated with repayment income. But I do want to take a second to point out that rental income must be included in annual income, regardless of the length of time that it is received. If you have any questions or you're looking for further guidance on calculating annual income, our team just did a great presentation on calculating income and assets, and you can find that in our LINC training and resource library. Now, if the credit report reflects late mortgage payments on the rental property in the past 12 months, then the full mortgage liability and all associated costs must be included in the monthly debts. Now, for mortgages with no release of liability, so if we have mortgages, mortgage liabilities that were disposed of through a sale, trade, or transfer without a release of liability, so the borrower remains on that promissory note, then we must include that debt in the debt ratio unless evidence can be obtained to confirm the remaining party or the new owner has successfully made the payment for the previous 12 months prior to loan application. And that evidence can be reported through the credit report or verification from the creditor or servicer to document that payment history and that has been current for the 12 months prior to loan application. Again, if there's any late payments in the last 12 months prior to application, the full mortgage obligation must be included. In situations of divorce, the lender must obtain a copy of the legal separation agreement or divorce decree to document the remaining party responsible to pay all those mortgage debts from the effective date of the decree forward. Now, to exclude the mortgage debt, the lender must document the previous 12 months have been paid as agreed prior to loan application. And again, that can be through the credit report or through verification from the creditor or servicer. If there were any late payments in the past 12 months, then that full mortgage obligation must be included in the monthly debts. Cosign debts. If there are any cosign debts, those have to be included unless the applicant provides evidence, again, that another party to the debt has successfully made the payment for the previous 12 months prior to loan application. Acceptable evidence can include canceled checks, money order receipts, bank statements of the other party, and it's not limited to just those, but that's typically what we would see for evidence of that payment. And again, any late pays reported in the last 12 months, we do have to include that. However, if the applicant can provide conclusive evidence from the creditor that they will not pursue debt collection against them should the other party default, we can waive that 12-month payment history being required. And always debts identified as individual on a credit report must be included in the debt ratio regardless of who is making that payment. So for example, if parents are paying a car payment on behalf of the applicant, and the loan is solely in the applicant's name, we have to include that debt because it is a debt of theirs. Even if mom and dad are making the payment, it is identified as their debt, so we have to include it. All right, business debts. Business debts, such as a car loan reported on the applicant's personal credit report, may be omitted from the monthly debt if there is evidence the debt is paid through a business account. Again, acceptable evidence could be canceled checks or bank statements from the business account from the previous 12 months. Another update to Chapter 11 as of yesterday is under this topic, and it's that payments paid by the business must be included on the cash flow analysis and or profit and loss statement as appropriate. Now, for community property states, which would include Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin, those are all community property states. The debts of a non-purchasing spouse must be included unless excluded by state law. It is the lender's responsibility to know those state laws and to cite the specific state statute in the permanent case file if they are excluding those debts. Expense allowances, an automobile or other expense allowance will not cancel out a monthly debt for the debt associated with the car or other type of expense loan. The full amount of the monthly debt associated with that expense, so such as a car or equipment payment, must be included in the debt ratio calculation. Again, refer to Chapter 9 for guidance on calculating income for expense allowances. And again, I just want to note that for annual income, include amounts documented on the payment statements as taxable gross earnings that will be received in the ensuing 12 months. If it is included in taxable gross earnings, you do have to include that in the annual income. For balloon or deferred payments, those will require payment in full upon their due date and must have a payment included in the monthly debts. When that balloon or deferred payment loan is due within 12 months, the lender must evaluate the complete loan application and make a determination regarding the applicant's repayment ability. If the actual payment is unknown, then the lender may obtain documentation from the creditor to establish a monthly payment that will be due and document the payment date, or they can use 5% of the outstanding balance that's on the credit report or the verification from the creditor. For tax repayment agreements, you want to include federal or state income tax repayment plan payments in the monthly debt. If 10 or less months of repayment remain per the plan, the monthly debt may be excluded, again, if it does not exceed that 5% of the monthly repayment income. And if you want some more guidance on how this affects credit and eligibility, you can refer back to Chapter 10. For lease payments, so any type of auto, solar, energy, or any additional type of lease payment, those must have the payment included in the monthly debt regardless of months remaining to pay the contract. So that one's a little unique in that we are not looking at, that 10 months. So that when you, regardless of the months remaining, you always have to include that payment. And then the same thing with debt management plans. You always want to include a monthly payment amount due from the counseling plan, regardless of the time remaining on that. All right, so now we are going to take a look at debt ratio waivers. And again, this is an area where yesterday's update of Chapter 11 that was announced through the Gov Delivery announcement, we have a couple of updates when it comes to waivers. The first thing I want to point out is there are different requirements for waivers based on whether the loan is a purchase or a refinance loan. First, we're going to take a look at debt ratio waivers for purchase transactions. So the next couple slides are specifically talking about waivers for purchase transactions. The applicant's total debt ratio may not exceed 41%, or the applicant's total debt ratio may exceed 41% if the lender determines that strong compensating factors demonstrate that the household has higher repayment ability. But note that no waivers are permitted to increase the PITI ratio above 34% for purchase transactions. So again, as of yesterday, we increased that ratio for PITI from 29 to 34. but that's it. Now it's at the 34. We cannot grant a waiver to go above that 34%, but we can still consider a waiver to exceed that total debt ratio of 41%. So for GUS files that receive and accept or accept full documentation underwriting recommendation, a debt ratio waiver is not required. So regardless of what the ratios are in GUS, if you received an underwriting recommendation of an accept or accept full documentation, you do not need a debt ratio waiver. If the GUS recommendation was a refer or a refer with caution, or the loan is a loan type that's not supported by GUS, such as an existing manufactured housing pilot loan, then there must be documentation to support eligible compensating factors for a debt ratio waiver. USDA's concurrence of a lender's request for a debt ratio to exceed 41% may be granted if these four conditions are met. So the first thing that you want to look at is the maximum PITI ratio, again, cannot exceed 34%. That is the max. And then the maximum total debt ratio cannot exceed 44%. The validated credit score of all applicants must be 680 or greater. And then at least one acceptable compensating factor that we've outlined in Chapter 11 must be present, and supporting documentation must be provided to USDA and maintained in the lender's permanent file. So what are those compensating factors that you can look at for a debt ratio waiver for purchase transactions? We have four of them. The first that you can consider is that the applicants have accumulated savings or cash reserves available post-closing. So this would be post-closing that are equal to or greater than 3 months of PITI payments. And cash on hand is not eligible for this compensating factor. The next option would be that the applicants, all applicants, which include all employed applicants, have been continuously employed with their current primary employer for a minimum of 2 years. If the applicants have received Social Security benefits or retirement income for 2 years, this option may be utilized. You just have to document and support the history and receipt of those benefits. Now, if the applicant is self-employed, this compensating factor is not eligible. They cannot use this if they are self-employed. So you would have to look at one of the other compensating factor options for them. The next option is that the proposed PITI does not exceed the applicant's current verified housing expense by more than $100 or 5%, whichever is less, for the 12-month period preceding loan application, and there cannot be more than one 30-day late payment for the previous 12 months. Then the last option is that the subject property is an energy efficient home based on the International Energy Conservation Code standards. The lender is responsible for verifying and documenting evidence in their permanent loan file that the IECC standards have been met. And if you want more information on what would qualify for those IECC standards, you can look at Chapter 11. It outlines what those requirements are for that compensating factor. All right, so those couple slides we talked about ratio waivers for purchase transactions. So now let's take a look at if a waiver is required for refinance transactions. Again, GUS files that receive and accept or accept full documentation underwriting recommendation, those do not require a debt ratio waiver. Again, regardless of what the ratio or the ratios are, if it received an accept or accept full documentation underwriting recommendation, you do not have to submit a debt ratio waiver. If the loan received a refer or refer with caution underwriting recommendation, or again, it's a loan type that's not supported by GUS, then we need supporting documentation for that waiver. There is an exception to this for streamlined assist refinance loans. We do not require a debt ratio calculation, therefore no debt ratio waiver would be required. All right, so what would be some acceptable compensating factors for a refinance transaction if a debt ratio waiver is needed? For the refinance transactions, we have 5 options available for compensating factors. The first would be that the validated credit score of the applicants is 680 or higher. Now, back with the purchase transactions, it was required that the credit scores, it wasn't a compensating factor, it was just a requirement that all applicants have a credit score of 680 or higher. When looking at the debt ratio waiver for a refinance transaction, we actually consider a credit score of 680 or higher as a compensating factor. And then another option for a compensating factor for a refinance transaction would be that the proposed PITI does not exceed the borrower's current verified mortgage payment by more than $100 or 5%, whichever again is less for the 12-month period preceding loan application. Again, we can look at that accumulated savings or cash reserves available post-closing that are equal to or greater than 3 months of the proposed PITI payment. We can look at continuous employment with the current primary employer. And then we can look at the home, again, being an energy efficient home. All right, a couple more notes that I just want to point out on ratios is we can also look at, so when you're looking at your applicants' ratios, one thing to consider is increasing their purchasing power. A couple of things to consider would be paying down installment debt to 10 payments or less, if allowed by the lender. You can consider mortgage credit certificates, and there's more information in Chapter 9 for MCC guidance. We could consider funded buy-down accounts, and there's more information in Chapter 11 on buy downs, and then also Section 8 home ownership vouchers. And there's some guidance in Chapter 9. So again, these are just a couple things I wanted to mention that is another option to look at for increasing your applicant's purchasing power. Now, there are some debts that we don't have to consider in the debt to income ratio. This is not an all-inclusive list. These are just, I think, some of the more common debts that we would see that we just wanted to point out that don't have to be included in the debt ratio. And some of these would include medical collections and payments, retirement contributions such as 401k accounts, and that would include repayment of loans that the applicant may have taken against their 401k. Utilities, insurance other than their property insurance, and union dues. Childcare expenses, none of those would have to be included in their debt ratio. All right, now we just want to share with you some frequently asked questions that have come into our scenario desk that we thought were really good questions that maybe, the answer to them isn't quite, black and white. You can't quite find the exact answer maybe right in the handbook. And so we wanted to share some of these with you that were related to ratios. So the first one that we wanted to share with you is an applicant currently has student loans. However, she continues to work for her employer for the next 10 years. The student loans will be forgiven. Is a student loan repayment or is the student loan payment required to be considered in this scenario? And the answer to this one is yes. because again, those student loans in a forgiveness plan remain the legal responsibility of the applicant until they are released of liability from the creditor. Therefore, we must include that in their monthly debts. All right, another good question is an applicant has student loan debt that is on an income-based repayment plan and currently has a zero payment. Do we have to include that in their monthly debts? And again, the answer is yes. Because it had a zero payment, we have to use 0.5% of the outstanding balance. Another one with student loans, if it is currently in deferment, do we have to include that as a liability? And that one is yes. Because they're in deferment, we have to use the payment amount reported on the credit report, the actual documented payment when it is greater than zero, or that 0.5% when the payment is zero. Can an installment liability with less than 10 months of payments remaining be omitted? And this one is a maybe. Again, we have to look at that monthly payment, and we have to look at whether or not it exceeds 5% of the monthly repayment income. If it does not exceed 5% of the monthly repayment income, then it may be excluded if there's that less than 10 months remaining. But if it does exceed 5%, then we always have to include it regardless of the months remaining. And then can an applicant pay off a debt at closing to qualify? And again, the answer is maybe. This is all going to depend on source of funds that are used to pay off that debt. Applicants may pay debts at closing as long as loan funds or seller concessions are not used to pay the debt. And then it is the lender's responsibility to ensure debts paid at closing are out of the borrower's personal funds. This question, an applicant is divorced and the ex-spouse was given responsibility of a few credit cards and an installment loan evidenced by the divorce documents. The debts are showing on the applicant's credit report and are paid as agreed with no late payments. Can these debts be excluded? And the answer again is maybe. It's all going to depend on the payment history and length of time. So we have to look at those co-signed obligations must be considered in the debt ratio unless the applicant provides evidence another party has made the payment on time for the previous 12 months prior to loan application. Or that other option is that the applicant can provide conclusive evidence from the creditor that they will not pursue debt collection against the applicant should the other party default. This question, does the payment on an authorized user account need to be included as a liability? So we would be looking at authorized user accounts. And the answer to this one is no. So if the applicant is solely an authorized user and has no legal liability to repay the debt, it can be omitted. A co-signed debt has only been open for 7 months. However, we have documentation the other party has made all payments. Can we exclude that debt? And the answer is no. A full 12-month history showing another party is paying the debt is required to omit the payment. All right, so those were, again, just a few of the frequently asked questions that have come into our scenario desk. We get some really good questions. Anytime you run into a scenario that you just aren't quite sure the answer to it, you might not quite find the answer in the handbook, please reach out to our scenario desk and they can help you interpret the, the area of the handbook that would be associated with that. And then as we wrap up today, I just want to go over a couple of our resources and tools that we have available for you. The first tool that we have is our USDA LINC training and resource library that you can find at the link that is listed on this slide. I highly recommend that you save this as a favorite if you're new to the Guaranteed program, haven't worked with it a lot. Definitely bookmark this page. This site here houses all of our resources and tools for you. You can access the handbook that I've been talking about the last 40 minutes or so. Every time I say handbook or chapter 9, 10, or 11, what I'm referring to is our handbook 13555. That is the handbook for the Guaranteed program. It is probably the best resource. It is broken up into multiple chapters that talk about specific topics. It's very easy to follow. It's very thorough, does a wonderful job interpreting our regulations and providing guidance to our lenders. So definitely always, if you have a question, go to the handbook and see if you can find your answer there. In the LINC training and resource library, we also have a number of user guides and training. So if you're looking for a little bit of training or guidance on how to use GUS or the lender loan closing system, we do have some wonderful user guides that walk you through step by step how to use each of those systems. If you are involved with loan closing or loan servicing, we also have guides out there to assist you in those areas as well. You want to make sure that you sign up for our Gov delivery notifications. If you received an invite to this training directly, you most likely are already signed up for them. But if the invite was forwarded to you from maybe a colleague that got it through Gov delivery, you want to make sure that you go out and you sign up to get those email updates directly to your inbox. Anytime we have any important update regarding the program, it goes out through a Gov delivery notification. I promise we do not spam you with a lot of email. We reserve those updates only for pertinent updates regarding the program. So it'd be something with maybe a handbook update or a training opportunity. So do make sure that you are signed up to receive those updates. This here is the link that will take you specifically to that 3555 handbook. Again, as I mentioned, you can see it is broken up by multiple chapters that talk specifically about a topic. So if you have a question, again, today we talked about ratio analysis, which is chapter 10, but if you have a question about maybe income, you can open up chapter 9, do a search and quickly find your answer about something specifically to income. Let's see, the questions that I used for today for our little trivia segment, those came from our FAQ document that is out on the LINC library. Again, another wonderful tool when you have a question about the program or a specific scenario, come take a look at this FAQ document because it may be a question that we've received from another lender. So you can go and search this, and if the answer is not in the handbook, not in this FAQ document, then again, certainly reach out to our scenario desk for assistance. And then lastly here, we have our contact list. If you need assistance, we're definitely here to help you with whatever question, concern you may have. If you are looking for a question on policy, you would want to reach out to our policy team. If you are looking for some training, that would be in addition to the training that you just had today. If you're looking for maybe some one-on-one training, some more in-depth training for your team, you would want to reach out to my team. That would be the Lender and Partner Activities branch. Just reach out to us and we would be more than happy to set up a date and time to meet with you and your team for some one-on-one training. And then if you have a question about a specific loan file, so if you've already submitted a loan file through GUS and now you have a question about it, then you would want to reach out to our OPD team. That's the Origination and Processing team. And we have 4 teams and each of them are responsible for a certain state. So depending on the state that the property is located in, you would want to reach out to the respective team for that state, and they'll be able to help you with that specific loan file. And then the last thing I actually want to point out today is a new addition to our LINC library, and that is our policy desk. So as I mentioned yesterday, our updated Chapter 11 for the Handbook was released, and we now are posting, before these Handbook chapters go into effect, we do post a draft of all of our policy update draft handbook changes to this policy desk, and we do have the opportunity for lenders to submit their comments. So once you review the draft changes that we have posted to the policy desk, you can submit your comments to us. It's very important to us that we include our lenders, all of our stakeholders on our proposed policy revisions before they go into effect. We want to hear your feedback after you review them. So when you get that GovDelivery notification that there is some proposed changes coming to our handbook, please take a look at those drafts. And if you have any comments, go ahead and submit those to us so we can review those before the final changes go into effect. All right, and so that is all I have today for our presentation on ratio analysis. So I just want to thank you all again for taking time and joining us today, and please enjoy the rest of your day.